Arguments in Donald Trump's immunity case took more than 2.5 hours at the Supreme Court today. Case took a deep dive into the nuances of immunity as Trump's legal team tries to avoid his prosecution in the election interference trial. Martin Redish, the Lewis and Harriet Ansel Professor of Law and Public Policy at Northwestern School of Law, is joining us now. Professor, thanks for joining us.
My pleasure, Micah.
First of all, this case troubles you, doesn't it? Why?
It troubles me significantly because the framers were most concerned about the dangers of tyranny. And the one branch of the federal government most likely to devolve into tyranny is the presidency, which is serves as the commander in chief. And if the president is immune from prosecution for criminal acts, as the Trump legal team was arguing, there are no limits, there are no restraints on what the president can do. The conservative justices today were very concerned about improperly motivated attorneys general in the states or federal prosecutors, but they seem to express no concern at all about the danger of a president who has more power than anyone else in the nation, becoming a dictator through the use of criminal acts. The Trump team was asked, do you agree with what you said in the lower court that if the president used SEAL Team 6 to kill his opponent, he could not be prosecuted? And they said yes. That very answer should disqualify the position that they're arguing for.
Is this a case that the Supreme Court should have rejected and not taken up?
Well, I thought the opinion in the D.C. Circuit was excellent and in denying immunity. And I'm not alone in that. Many constitutional scholars agreed that this is not a place for immunity. Obviously, the Trump appointees on the Supreme Court seem to disagree with that. The question now is, well, where are they going to go? I don't think they're going to go on the basis of the argument. I don't think they're going to go to either of the extremes, either total immunity or no immunity. What's in between is somewhat complicated. There seemed to be a lot of talk about sort of a public-private distinction. I suppose that would mean if the president shoots his or her spouse, that would still be subjected to a criminal penalty. But beyond that, I think it's impossible to figure out what the distinction is. And I'm not sure anything should turn on it. The president can use his presidential power for evil means. And the framers were concerned with that very end. And the Supreme Court, at least a large portion of it, doesn't seem concerned at all with that problem.
So basically, the potential here could be they could make the office of the president above the law and could pretty much do whatever he or she wants.
There are some members of the court who seem to want to do that. I doubt they'll get a majority for that completely. But this public-private distinction will be a nightmare. It'll be almost impossible to figure out and would result in an endless number of appeals, I think.
Could this be pushed back to the lower court?
Well, that would be the option if they decide that there's a public-private distinction. It could go either to the Court of Appeals. Some of the conservatives wanted it to go all the way back to the district court, the trial court, to now roll up its sleeves and dig in and figure out what is public and what is private. And the one immediate political result would be that President Trump gets his goal of not having a trial or a conviction prior to the election. The one thing that's clear is that the Trump team has, as a political matter, effectively circumvented the danger of a conviction on this very serious matter prior to the election, I think.
Professor Redish, thank you so much. Appreciate it.
Thanks, Michael.